All right, this is case number 20 CR 215. State of Ohio versus Brittany Natalie Marie Haynes. The state is represented by the prosecuting attorney and the Collins assistant prosecutor King. Defendant is represented by her attorney Jason Vestatorich. You are Brittany Natalie Marie Haynes.
Yes.
Right. This hearing for purposes of sentencing. The defendant was convicted during trial by a jury last month. All three counts in the indictment: felonious assault, count 1, endangering children, count 2, endangering children, count 3. The court referred the matter for a pre-sentence investigation, and each of the attorneys received a summary of that.
State Your Honor.
Yes, Your Honor.
All right. The first order of business would be to address the issue of murder of counts 1 and 2. The court has reviewed the memoranda submitted on that issue as part of the sentencing memoranda of each party. Is there anything the defense would like to add to that?
Well, I would incorporate my sentencing memorandum by reference. Just briefly, we are asking for merger in this case pursuant to 2941, 25 Ohio Revised Code, using the Johnson and Ruff test. Ruff later clarified the Johnson test, asking whether it's possible to commit one offense and commit the other offense with the same conduct. We submit to the court that the felonious assault and the child endangering happened simultaneously by causing serious physical harm to the child, LH, and having the child be abused recklessly, which resulted in serious physical harm, was the same conduct. We prefer to point out that the state charged Ms. Haynes with one course of conduct. That course of conduct on the felonious assault was from June until September of 2020. The same course of conduct was on the child endangering was from June to September of 2020. There were no individual charges or separate charges for separate incidences. The jury was not asked to find, nor did it find, that certain circumstances were felonious assault versus other circumstances that were recklessly or child endangering. We would say that the state relied on the same evidence to secure conviction on both counts. So we do believe that the child endangering and the felonious assault merge under the Johnson and Ruff test, as cited in my memorandum, which I'll incorporate into my arguments. Thank you.
Thank you. Yeah, State.
Thank you, Your Honor. Again, we would ask the court also to consider our sentencing memorandum. And would first note that the defense asked this court to consider the Johnson case as being basically on point. However, it's definitely not. The events in Johnson all literally came out of the same course of action. The events in this case did not. The events in this case occurred over a period of time, talking 22 separate broken bones and a skull fracture. And actually, the jury was instructed, or the jury was asked to find two specific events to find the serious physical harm and the felonious assault in a different set of events in the F2 child endangering. The set of events that the state specifically appointed to for the F2 felonious assault was the event that happened on September 4th, as I've outlined in my sentencing memorandum, in which the defendant slammed Lucy's head against the floor and then knelt on her leg, putting all of the weight on her leg, causing her femur bone to break. If the court recalls, the specific events that led to the child endangering, the reckless action of the defendant was the jerking of Lucy when she was stuck behind the crib, which occurred, according to the defendant's own statements, as well as the expert testimony of Dr. Thackeray on 2 separate days. The expert testimony was that these injuries did not occur at one time as in the Johnson case, but rather over a period of time. Based on all of that, I would ask the court to find that these 2 crimes do not merge for purposes of sentencing. The defense pointed out that one is a predicate offense for the other. My understanding of predicate offense is that predicate offense is the offense that must be committed in order to commit the greater offense, for example, a theft and a B&E. And that's definitely not what we have in this situation. Neither of these crimes require a predicate offense that I'm aware of. So based on all of that, we would ask the court to find that these are not 2 sentences that would merge for purposes of sentencing. These are 2 separate crimes committed on 2 separate days, as was found in the evidence, and as was pointed out to the jury, and as the jury also agreed upon. And based on that, we would ask the court not to merge these for purposes of sentencing. Thank you.
Yes, Your Honor. We just simply disagree with that statement about the separate offenses. The state points out the September 4th as what they relied on. However, in the jury instruction and in the indictment, there was no specific dates as to which events occurred on which days. It was a period of time from September or through June of September of 2020. We do think that Johnson is on point because of the specific finding that the jury did make, which is that it related in substantial or serious physical harm, which is the same as felonious assault causing serious physical harm. So we are saying that the causing of the serious physical harm is merged with recklessly abusing. And under the Ohio Revised Code, the mens rea for both of them, if you satisfy knowingly, you also satisfy recklessly. Thank you.
Well, actually, the most recent case on the issue of murder is the Ruff case, 143 High State Third 114, which further attempted to clarify Supreme Court's interpretation of murder statute 4941.25. And in essence, the court has to look at whether the each offense caused separate identifiable harm, were the offenses committed separately, were they committed with separate animus or motivation. And it is, in fact, a fact-specific analysis. There's no right-line rule. And so the court has to look at the evidence. And the court a little surprised about the argument that it's not murder because look at the bill of particulars, and the bill of particulars filed by the early state, and I do have that complete part of the record here today, 46.1, is that it's identical language in tab 1 and 2. If there's any differences, I can't pick them out, but I will make a couple of quotes in each of those cases. It states that Haynes admitted she had likely caused a skull fracture and brain bleed. She put LH down for an employee, and then it goes on. And then the paragraph states, State Children's Hospital examined LH found 23 separate fractures. And then the final sentence is 23 separate fractures, broken bones, and serious physical harm. The identical language is in page 2. Both are alleged to have occurred over the same period of time. And honestly, the only time I can really recall the separation of them, I know the state developed that in the closing argument, but it can't be separated out, of course, because it was, you did indict it as 2 separate instances. You did indict, you did indict the skull fracture as a separate serious physical harm, and the 22 bone fractures as a serious physical harm. They weren't separated out in the indictment, and for that matter, I was going back through my notes and looking at it. I mean, I think the totality was that the totality was serious physical. Also, I don't know that there's evidence that there's a separate animus as to each. fracture, at 22 separate fractures. The argument is, each teacher, and I agree, the evidence says that they were of varying ages and abused and occurring on a regular basis. It was in the same connection of the child being in the defendant's care. I don't think that there's evidence of separate animus, and the state did not ask the court to instruct the jury to identify separate harm or separate count 1 and count 2. It was just everything was the same. So based on that, it's the conclusion of the court, using the Johnson as and the Rupp cases, that these counts 1 and 2 must merge. The court orders they merge. Only one sentence imposed, and under the statute, the state has the right to elect as to which count to be sentenced on. So, what is the state's election as to count 1 or 2?
1.
All right. That's noted, so then the sentence, proceeds sentencing on counts 1 and 3. All right. Anything in the state regarding sentencing?
Your Honor, it's the state's position this defendant should be sentenced to the maximum term allowable by law. 8 years on count 1 during consecutive to 3 years on count 3, for a total of 11 years. Red totes does apply in this matter. We would note that, as the defense asked this court to do, look at where sentencing in other similarly situated cases. I pulled 4 that I can recall over the last 15 years. However, none of them are as serious as what this defendant did to her children. I pointed those cases out in my sentencing memorandum. The Coonrod case, he was convicted of 2 F3s, child endangering, and was sentenced to 5 years on each to run consecutive to one another. And the Dennis Lechner case, while not a child, she was a victim that was in a wheelchair that he hit and caused, I believe, a broken jaw. He was sentenced to 7 out of 8 years. Martin Proctor was an event that was a one-time, it was a felonious assault, not over a period of time, but one event in which he caused the broken leg of, I believe she was 3 years old. He was sentenced to 6 years on a plea of guilty. He showed genuine remorse, crying in the courtroom. And then Robert Kirby was charged with an F3, child endangering. Again, at the time, it carried a 5-year maximum prison sentence. He also entered a plea of guilty and showed genuine remorse. He too basically snapped one night and caused a skull fracture to the child that was under his control. She was an infant. He was sentenced to 4 out of 5 years in an F3, child endangering, again showing genuine remorse, which has definitely not been shown in this case. I would ask the court just to remember the defendant's actions at trial, her demeanor in the courtroom, her cussing from the witness chair. Would note that as soon as she was taken into the jail, she immediately stated that she thought she was pregnant again. During her phone conversation, since her bond has been revoked, not one time has she ever mentioned these kids' names. She doesn't talk about them at all. So any statement that she wants to reunify and have a place in their lives is just nonsense. She's been completely uncooperative with Children's Services. She won't even speak with the caseworkers. There is nothing to show that she has any sort of remorse other than remorse in that she got caught and that no one believed her story that this is somebody else's fault. Frankly, it's somewhat offensive that today she decided, well, in her sentencing memorandum, blames a rough childhood for this. I mean, I read millions of Facebook messages talking about everything under the sun, and at no point does she ever talk about being sexually abused as a child. That was something brand new. There's absolutely no evidence of that anywhere, but there is evidence that 2 people that testified against her were victims of sexual abuse. They both have testified in this court, and both of them have grown into amazing young mothers, caring, kind, generous people that, while they actually have evidence of being victims, haven't done anything like this defendant did. To excuse her conduct or even to use and allege what she alleges was a rough childhood as an excuse for what she did, it is setting the precedent that, you know, if you grow up in a rough family and you grow up, and you abuse kids, or you become a thief, or you become a murderer, well, it's okay because I had a rough childhood. No, it's not okay. And then look at the crime in this case. I mean, 22 broken bones and a skull fracture and a baby that's 3 months old that literally relies on her for everything. It's inexcusable, and it is the worst form of the crime to be seen in this court and deserves the maximum penalty. For some reason, I'm not sure why, the fact that William was eating out of a trash can has bothered me more in this case than anything else. It has affected me greater than anything else I've read in this case, and I don't know why. It just really, really has. I don't get emotional in cases very often, but the fact when I found that out, it was emotional to me. It really, really bothers me. Again, the worst form of the offense that I've seen in neglecting a child, there's just no excuse for it. And again, she deserves the maximum penalty. If anybody that's walked through here does, she does. Based on all of that, we would ask the court to give her the same. Thank you.
For the state's is agreed that even though it's an F3, child endangering is a low tier offense, not right?
Yes.
I don't know why it's there.
I don't either.
Is. Okay. And there was no victim representative appointed. I don't have a victim impact statement. Is that correct?
No, there's not.
Thank you. All right. Mr. Dustin First.
Thank you, Your Honor. Pursuant to the principles in 29-29-11 and 29-29-12, we'll be asking for sanction of either community control or a sentence less than the maximum as requested by the state. Under 29-29-12B, the seriousness factors, we would submit that according to the factors outlined in the higher revised code, that this offense was not more serious conduct than normally constitutes the offense. We point to Ms. Haynes' remorsefulness, and I will get into that in a second, that she did not use her professional occupation or reputation to facilitate this crime. Although she was the mother of these children, her relationship with the children did not help facilitate this crime, and that she did not commit this offense as any kind of organized crime or for hire, and that race or gender was not a motivation in conducting the offense. 29-29-12C, Ms. Haynes' conduct was less serious than the conduct normally constitutes the offense. Once again, feels genuine remorse. I will go into the mitigating factors after I'm done with the code sections. However, although it doesn't constitute a defense, the mitigating factors that we would be pointing out to is Ms. Haynes' physical and sexual abuse that she suffered over the course of many years. We would point out that this was not a premeditated crime. As to the recidivism factors, in 29-29-12C and D, we would point to remorsefulness of Ms. Haynes, that she was not under post-release control or probation at the time that she committed these offenses, that she had no prior criminal record, meaning that she led a law-abiding life all through until this indictment, and moreover that alcohol and drugs were not a contributing factor to this offense. There was no allegation of alcohol and drugs as to this offense, and she was tested on bond and tested clean. As to the genuine remorse, Ms. Haynes knows that coming in here and owning up to what she was convicted of would go a long way with this court. However, she has maintained her innocence on the felonious assault portion of this, stating that she did not cause any serious physical harm to these children. That being said, she does wish that she would have did more to help protect these children, and understands the situation that she put these children in. The state did point to her conduct while on the witness stand. I will point out that she was under a rigorous cross-examination, most notably of most of her Facebook posts. She did tell a different story on the witness stand than she did in her interviews. She maintains that that is what actually happened in this case. She's not saying that to minimize it or demean the seriousness of this offense. She knows that serious physical harm did happen to these children, is remorseful for the fact that she didn't step in and do more to help these children. She did say on the stand that she loved the children, that she wishes that this would have never happened. However, it did happen. I will also point out, not an excuse for childhood. It's not an excuse for what happened here. It's not meant to be an excuse. It is meant to be a mitigating factor for the court to consider in her sentencing. She was sexually abused as a child by multiple individuals. Her father went to prison for sexual abuse of minor children. She had a child of her own. She was 16 years old at a very young age. Had her second child when she was 17, turned 18 about a week later. And that's what led to the 3 months of the indictment, that period of time. She's not saying that as an excuse. She is saying that's what, as a social history of herself in a PSI and in a sentencing memorandum, that is what she would like the court to know. In addition to that, we would ask the court to waive court costs and fines in this matter, saying that she is indigent. She's currently incarcerated, and it's anticipated that she will be incarcerated for some period of time. She no longer has a job. She no longer has employment. If the court is inclined to incarcerate her, we would ask the court to find that she's indigent of being incarcerated for this period of time in the foreseeable future. I did not see a jail time credit on the PSI, but I believe that there is some jail time credit to be calculated. Thank you.
Right. Hayes, is there anything you would like to say? You're not required to say anything, but the court will hear whatever you would like to say at this time.
It's not that I do love my kids. I love my heart. I'm sorry that it didn't work.
I'm sorry that you won.
That it didn't work for them.
That's all. Well, it doesn't sound like a lot of remorse to me. And you're just continuing the pattern of lying that you established from day one when this case started, and that is you're saying you didn't do more protecting, still trying to blame everyone else. And quite honestly, I mean, I have to go back and read the transcript to keep track of all the different lies that you told and different people that you blamed, trying to explain away these injuries, including half-sister and sister, half-sister, and father, friend, I mean, anybody else that you could blame, you could blame. And just whatever you thought might work. And when that didn't work, it was something else. And basically, a pathological liar. You just couldn't tell the truth. Because the truth was, it was you that was causing the harm to this show. And I don't think there's any question about it. Certainly the jury found that. And I think that was absolutely correct finding. And it was evident from your demeanor. You are the biological mother, but you were anything but a mother to these children. Your son, the condition under which he lived, and the behavior that he developed because of what you were doing to him, basically starting him to death, is despicable. There's no other way to describe it. And I have to agree with the prosecutor, and unfortunately been around a lot longer than she has. This was just appalling testimony and facts that a child of his age would grab food out of the garbage and would grab onto his food and shove it down in his mouth so quick that obviously he was afraid if he didn't, it was going to go away. It was clear that he wasn't getting better. And the evidence is pretty clear that the only important person in your life was you. The children were an inconvenience. And you didn't have the attitude of love at all. And what this little boy went through is just unbelievable. And I just hope and pray that he won't remember when he gets older what he went through, because quite honestly, you know, his life was a living hell. And you're responsible for that, and no one else. You know, do not feed that child, not properly cared for. And from the evidence, you know, you weren't the one taking the doctor. This person was. But the more time he spent with you, the worse his condition was. And from what I read in the report, the pre-sentence report now, that and was testified to in trial by the foster parent, that he is driving. Yeah, he couldn't even stand up on his own and walk. At that age, it's unbelievable. It is unbelievable. It's clear that the boy got no attention from his father. At least no good attention. He couldn't speak. He couldn't show any affection. And clearly, that is clearly a result of the person who was most responsible for his life and his health, and that was you. And you have no one to blame for that but yourself. You did it. Now, with regard to your daughter, you know, there is, I mean, without question, in the law, this is the worst possible form of the offense in count 1, felonious assault. I mean, she wasn't even 3 months old. What worse victim could there be other than a helpless infant that you brought into this world? And the 22 fractures, bones plus his fractured skull, is just unbelievable. And then you stand there and tell me you're sorry you didn't do more to protect her. You're not admitting that you did anyways. You're still blaming everyone else. And, you know, if you want to live in that world, you know, I can understand why you want to do that. Because you can't bring yourself to admit from a low life that you would have to be to do what you did. I mean, and that's what it is. And I'm not judging you other than by your actions. The evidence, that's what the evidence says that you did. And in the law, there can't be any worse more than what there was in either of these two counts. And so it is the judgment of the court that you are arguably sentenced on count 1, felonious assault, to a definite term of 8 years in prison. Now, pursuant to the court's law, that will be the sentence that you will have to serve set by the court. The Department of Rehabilitation and Corrections does have the authority to determine if you should serve an additional period of time beyond that, based upon their evaluation of your case and you while you're serving your sentence. And that means they could increase that sentence to be by 50%, meaning they could increase it to a total of 12 years. And that would be up to them, of course, not involved with it. That they do, which is based on the evidence. The evidence calls for almost incarceration as possible under the law. Because I do have concerns about you committing this crime again, having more children, and there's nothing in the world that makes me believe that you will change your behavior. And unfortunately, experience, at least my experience, has shown in 45 years in this business that people who leave children, they don't stop. So the children get old enough to protect themselves, or they are stopped by the law, which is what happened here. So, hopefully you are not pregnant. Be shame for you to have a child when incarcerated, but court is concerned about a future victim. You are also ordered to serve a period of 36 months on count 3. Again, both of these are the maximum sentence, and the court finds that each of these offenses were the worst possible form of the offense. The court finds, 12.9, 2912, that the victims each suffered serious physical harm. The physical harm that they suffered was exacerbated because of their age. Less than 3 months and less than 15 months. And, contrary to what your attorney says, your relationship in fact did facilitate the event because you were the mother, her mother. That wasn't their fault. They were born then, and that they had no choice in the matter. And because of that, when they being in your custody, that allowed you to continue to use these children and inflict this harm. The court does not find that there's any mitigating circumstances here whatsoever. The court does not feel to have shown any true remorse. And the court also finds that consecutive sentences are warranted under the law. I think they're demanded under any sense of justice. But under the law, these offenses were committed as part of one or more courses of conduct, and the harm was caused by the offenses that were so grave and unusual one single prison term. It does not actually reflect the seriousness of the conduct because you have two separate victims, two separate types of harm, and one starving your son to death. Eventually, that's probably what would happen. But this hadn't happened, and you've been caught. And as to your daughter, the 22 fractures plus the skull fracture, that's separate harm, separate type of harm. So it's necessary for the sentence to reflect that you had two separate victims, and each of them suffered separate and identifiable type of serious physical harm. And the court finds that this criminal conduct, although it's not extensive as your first offenses, these two facts alone, these two offenses alone, are clear indication that consecutive sentence is necessary for public, particularly children, whether it be your children or someone else. Now, jail time credit will be granted in 63 days for the sheriff's certification. Now, upon completion of the prison term, again, since it's 8 years, is going to be minimum plus 3 years, 36 months of count 3. So the total sentence between count 1 and count 3 is 11 years. And then the maximum could be 15 years because the rule in current corrections can add 50% to your sentence on count 1. And so that additional 4 years then would make that possible 15. Now, upon completion of the prison term, whatever it will be, whether it be the amount set by the court or additional amount that would be ordered on count 1 by the Department of Prosecution Corrections, when you complete that sentence, the adult parole authority will place you under post-release control supervision for a period of 3 full years. That's count 1. And actually, no, child endangerment is offensive violence.
No.
I was thinking it was.
It's reckless, it's not.
Okay. All right, well, in any event, count 1 is mandatory. Count 3 then would be optional. But it's going to be happening. You're going to be in post-release control for 3 years, plus conviction on count 1. That means you'll be supervised on the terms set by the adult parole board, by a parole officer. And if they determine that you have violated those conditions during that 3-year period, they can return you to prison, making sure an additional period of up to 9 months for one violation, up to a total of 1/2 of the prison term imposed by the court, which would be a total of 11 years, so it would be 5.5 years. At this point, I don't think that the interpretation is that they could increase that to include the additional time added under the regular codes. But if that were to become the law, then that means it could be additional, a total of 15, so it would be a total of 7.5, if that were the law. I don't believe that it is, but I'm just telling you that, so it's in the record in case that is what happens. That period of time, I don't be for anyone in this court. Now, in the event that you commit a felony while under post-release control supervision, Then, in addition, wherever sentence a judge in the new felony case can impose upon you, that judge is also authorized to sentence you in this case for violating or committing a felony while under police control in this case to an additional period of 1 year or whatever time is left on that period of police control, whichever is greater. If that occurs, that must be served secondly to sentence in the case. Now, you're also ordered to pay the court costs, which doesn't grant execution order. You can't pay that, not make arrangements to pay it, and then upon completion of your prison term in the court at that time, or you do service and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your credit by that amount until paid full. Now, Haynes, you have the right to file an appeal from the conviction and the sentence of the court in this case. That appeal will have to be filed in 30 days for sentencing entry being filed, which will probably be today, so that will be 30 days from today, and that will have to be filed in writing with the courts. You are entitled to have copies of all of the papers in the record, as well as copies of the recordings and transcripts of those recordings and all the proceedings that occurred in this case to assist you in that appeal. If you are unable to pay for those, then the court will provide those to you at no cost. You are also entitled to have an attorney to represent you in pursuing that appeal. And if you are unable to hire an attorney, then the court will appoint one for you at no cost. Now, Mr. Despotoris, have you and your client made any decision as to whether or not there will be an appeal, and if so, whether or not you will be involved in that appeal?
We haven't had a discussion about if we're going to file an appeal. I know that if we do file an appeal, I will not be the appeals attorney. We would be requesting court-appointed counsel for that.
Well, here's what I would request that you do, and that is fairly common practice nowadays, is that I would ask that you file the notice of appeal to protect the client's right to that appeal within 30 days, because we have to find an attorney in the appeal for the times that it takes time. There's not, fortunately today, attorneys don't seem to be as broadly experienced in the defense sector anymore. Back in my day, we were trying to case appeal it, but now nobody does, and actually most of the attorneys who try cases don't want to do it, so we have to usually get somebody from out of state or out of county, and oftentimes even go to the public defender. And honestly, that sometimes takes longer than it does to get a private attorney to hire an appeal. So my concern is I'll make sure that the appeal is filed to protect the record. You can make that limited notice only in appearance for that purpose, just to protect the purpose.
Yes, if an appeal is filed, I will file a notice of appeal.
I appreciate that. Okay. Now, Ms. Haynes, once you've decided on the appeal, if you're going to appeal, you'll need to have the court determine whether it is or not. So, again, Mr. Despotoris, if you could indicate that, I don't think there's any questions you qualify for that. If there's no longer any funds to pay you from whatever source you was getting those from the court. So the court will appoint counsel once you determine that you wish to pursue the at some point we will need to fill out a financial disclosure. All right. Is there anything further from the state?
No.
Anything further from the council?
I would just put an objection on the record as to maximum sentences on counts 1 and 3. Thank you.
Well, as you know, under Ohio law, you don't have exceptions or no exception that done way before I became a lawyer, and I was repeatedly reminded by the judge when I became a lawyer here at that time. Yeah, here we go. All right.
Thank you.
All right, thank you. Ben?
Yes.
Please
Please rise.